mention that you gave her money?
It says thanks.
Okay. And did you take a picture?
No.
Okay. So there's quite a few of these that you never took a picture of, and there's nothing in the exhibits indicate that you gave that money to Miss Blair, but you want the judge to count it, don't you?
Objection,
question,
Your Honor, assumes facts, not in evidence. That
Well, he can just answer yes, even though you didn't take a picture of it. You want me to consider that as money paid. Is that true?
Yes, of course.
Okay. Now, at some point in time, and I'll ask you to focus on November 15th, 2021, where you say you gave Miss Blair $14,400.
Yes.
Did you ask for some of that money to go back to her?
What do you mean?
Get returned. Did you ask money to go back to you?
Oh, you said go back to her.
Oh, I'm sorry, go back. I apologize. In other words, out of that 14,000, did any money go back to you?
No.
Was it another time when money came back to you from money that you gave to Miss Blair?
Money never came back to me.
Oh, so every time you gave her some money, she kept it.
Yes.
Okay. Do you have a checking account, sir?
Yes.
And you were giving Miss Blair, according to your testimony, significant amounts of money at various times. Why didn't you use the checkbook?
She wouldn't take checks to her bank. She would not use the bank system. She made that very clear to Carla. Then.
Well, you would agree with me that a canceled check would have been the best evidence you could possibly get.
Not better than a picture.
Outside of a picture.
Yeah.
When you did take the
Yeah.
pictures.
Yeah.
Okay. Now, when you say you were ready to purchase, were you working with a bank or a credit union?
Yes.
What was the name of the bank or credit union?
I think it was First American Heritage.
And where are they located?
I think that branch is out of like California or something like that.
Do they have a local office?
No.
Okay. Did you apply for a loan?
Yes. And Carla applied too as well.
Okay. Did you separate loans or both of you combined?
I never finished my application process. I was in the beginning of my application process, but I didn't follow through with my final application because I didn't want to get the ding on my credit yet. But I had everything lined up just to that point.
Okay, so you never made the application.
Oh, I made an application. I didn't fill through with it. I mean, I can show you the stuff. Yes, I don't know how to answer that. Yes, I talked to the guy. I was in time with him. He got all my information. We were back and forth on everything. He wanted to get the hard run of my numbers and everything. I waited up because Carla was going to go through with her stuff. And then I was waiting on her to see who would get a better deal. We thought Carla would get the better deal. So we're going to go with her.
So you didn't then sign documents that says, I will pay First American Heritage whatever amounts of money they give me for a mortgage.
Not yet, no.
Not yet?
But we didn't have the opportunity to get the mortgage. She wouldn't sell us the house. How do we get the mortgage if we don't have the house to buy?
You said you were ready.
We were.
Well, ready means you have, approval from a bank or a credit union.
Objection to form, Your Honor. I don't know if that's a question or if it's testimony. It also makes.
Well, he didn't have the cash in hand, but his testimony was he had started the process and he certainly had time to complete it before all things went sideways.
Carla had done it. She'd done like the actual, we didn't both have to get a.
All right.
thing, right?
So you and Carla were working on financing for the purchase,
Yes.
but had not completed it or got a confirmation.
Is that true, what the judge said?
I had not gotten a confirmation. I believe Carla did.
Okay. And how much were you asking for the loan? Or what you would have been at, or miss?
It was like 355 or something, or what was it? I forget what the balance was, or the 335 or whatever it was for the balance. I believe it's 330. I gotta look somewhere to find out. I don't have it offhand. 335 or something.
Okay.
What's 112 minus 450?
Okay, we can do the math.
Wow.
And what, is there an interest rate that you were given, or?
I
Didn't
believe
get
you'd
that
have to ask
far.
Carl about that. I don't remember what that was.
Okay. And you never got approval for the loan, did you, from the?
Carla
bank?
did.
I understand that, but my question is, did you?
No, I said that.
Okay, thank you. Now, when the folks from Fabius Township came out, and I'm going to refer you to your council's exhibit. I find it so that we're all on the same page. Number 23. Is it 22? Thank you. You got it?
Yes.
Okay. You see the red placard,
Yes.
and you can read it. It's condemned, dangerous, keep out, so forth. Was that placed on your house? On the house at
Yes, it
Lakeshore
was.
Drive? Okay. Did you see that at any time?
Yes.
Okay. Did you take that condemnation notice in red off?
No.
No? Did Ms. Bowers or somebody else do it on your behalf?
I didn't witness anybody do it. No.
But
It did get removed. It's not one of them did. The one off the front, but not the one off the side.
okay, one of them got removed. And you don't know who removed it? Okay. And you notice that the green notice of violation is a couple days later, I think August 15th. Am I reading that correctly, you think?
Yes.
Okay. And
Objection, Your Honor, mischaracterizes the testimony. Or excuse me, mischaracterized the exhibit. I think that date is 8/15 for both of them.
I believe it is too.
And also, I'm trying to give opposing counsel some leeway here. I don't see any relevance about whether these notices were taken off, what that has to do with specific performance. So I'd like maybe some clarification about where we're going with this line of questioning.
well, counsel brought it up about how these things were so stressful and horrible and so forth. And I wanted to get into that a little bit because obviously one of the red placards was removed. And I want to know if he knows why there is a green placard after that.
I don't see.
I believe they're both the same date.
I don't see a logical connection between the stress of being.
No, he
kicked out
can
of the
ask.
property.
You went down that path. I'll let him wander down it a little bit himself. It's not gonna help me any, but it might make you feel better. So go ahead.
Was there a question? I'm not.
I'll withdraw my objection.
Thank you. Now, you indicated that you went back into the house even though the locks had been changed,
Yes.
okay? And the exhibit that your counsel provided was exhibit 24 that indicated that on October 14th, Mr. Fish had changed the locks. Is that, you think I read that right?
Yes,
And you testified to your counsel that you got in there on October 15th, the next day.
I believe so, yes.
Well, you drilled the lock or did you bust the window? How did you get in?
Oh, to get in the garage? I just
Well-
drilled through the lock.
Okay. Did anybody give you permission?
My house.
I see. So the answer is nobody gave you permission.
I don't need permission. Oh, yeah, no one gave me permission, sorry.
Thank you. And the locks were changed another time. Did you go back in after that?
Yes, it did.
Okay. Anybody give you permission?
Myself.
Okay, fair enough. In other words, you kept breaking in and the locks kept
I
changing.
kept going into my house.
You didn't need anybody's permission. You were there under color of lease. The lease had not been terminated by a court order, by me, or by a writ of eviction. There was a pretext of a condemnation, and the condemnation had been lifted. So at the point the condemnation was lifted, you had the availability to go back into your house. The actions of the defendant very clearly violated the landlord-tenant lockout law, which we had made a finding. It's also part of the default. So don't go down the path. You had every right to go into the house on those dates under the color of your lease option to purchase. And you didn't need permission to go in there.
Well, one of the questions I think the judge asked, and I'll ask it as well, is do you ever receive a bill from Miss Blair for the changing of the locks? Okay. And that was maybe 8 months ago, at least. Okay, thank you kindly. Nothing further, Your Honor.
All right. This is,
Sorry, brief
all right,
redirect.
you got 5 minutes. I've got to do that criminal matter at 2:30.
Okay. Is it a good time to break down?
Let's break. Everyone can use the restroom. I'll
Yep.
get the jail lined up and the public defender lined up, and we'll take care of that matter.
Thank you.
All right. Thank you. You're good to go.
Okay.
All right.
Answer the question.
Well, you can ask it. We'll see whether.
I just didn't know who I'm answering. Like, if you asked me, like, did you pay it? I'm like, no, I didn't pay it.
The beautiful part of my job is that I don't have to answer questions.
Okay, yeah, no, I didn't know if she, I forget. It's
All right.
not-
Anyway,
Yes.
I wondered whether there was a propane tank that perhaps ran out of propane or.
No,
In filling counsel in, previous counsel were involved in the matter at that time. There was a hearing set in January. And the matter was adjourned as I think Mr. Hauser came in. And then it got adjourned again by stipulation of the parties, I think a couple of times. And then we had I think we had a snow day. One of the days, and then we had a tornado day, but this was supposed to be dealt with right after the first of the year, and for a combination of reasons, it was not. Any further questions for this witness?
Yes, just briefly, Honor.
Mr. Soltis, you had an issue,
Well, my objection, Your Honor.
which
I
was,
can-
oh yeah, which I granted, we don't,
I can move on, Your
I'm
Honor.
curious, but I don't need to know that for this purpose.
Mr. Soltis went through with you, Mr. O'Donnell, on page 4 of Exhibit 18. There's a section titled Option Consideration. You see that?
yes,
And that states non-refundable option consideration in the amount of $5,000 paid by the tenant as consideration for this option purchase agreement shall be credited to the purchase price at the closing if the tenant timely exercises the option to purchase. You recall Mr. Soltis asking you some questions about the $5,000?
yes, I do.
Look on that demonstrative in front of you. What date was the Lease with option to purchase.
It's on November 15th.
Okay. Did you make a payment to Miss Blair? on
Yeah,
November
14,400.
Okay, so was part of that payment the $5,000?
Yes.
For the option?
Yes,
And that states that it shall be credited to the purchase price, correct?
yes, at the end.
So it's not like it was an addition to the purchase price, so it was gonna come off the $450,000.
Yes,
And it says, if the tenant timely exercises the option to purchase, do you see that?
yes,
So do you recall your testimony when Ms. Blair sent you a text message on or about August 4th, stating that she wanted to close on the property?
yes,
And then do you remember responding to that text message with confirmation that you intended to close on the property?
yes.
And how long did you have to close on the property?
3 months.
Could you have even closed on the property after August 4th?
Objection, speculative, Your Honor. He didn't finish up the application with Heritage, so he doesn't know if they would have approved it or not.
Well, was it your intention to close within those 3 months and?
Oh, yes, it
finalize?
was.
Would you close on a property that you were wrongfully evicted from?
No,
So if someone kicked you out of the house, why would you close within 90 days and pay her more money?
I wouldn't
after
give
she
her any
kicked you?
money, no.
So because of Ms. Blair's breach, you didn't have the opportunity to timely close on the option of the house. Is that correct?
Yes,
All right, you remember going through a lot of Mr. Soltis's question about there's no pictures of some cash payments. Remember that? Okay. And one of them was January 31st. That was a larger cash payment of $14,500, correct?
yes,
Okay, and the rest of the cash payments were $2,000 installments, correct?
yes.
Okay. Just because you didn't take a picture of the cash that you paid Ms. Blair doesn't mean that you didn't pay her the cash.
Objection, and I think that's this court's decision, not Mr.
Yeah,
he
he testified that he gave her the money and he testified that he didn't take a picture of it. And so it goes without saying, just because he didn't give a picture doesn't mean he didn't pay it. So he alluded to other evidence like bank records or something, but none of that is in evidence. But yeah, that's a question that doesn't even need to be answered because his answer is going to be yes.
You have permission to approach the witness.
Yes.
Mr. O'Donnell, this is $5 of cash. You see that?
Yes.
I'm not taking a picture of it. Can you pick it up?
Yeah.
Just because I didn't take a picture of that, does that mean that I didn't pay you?
No.
Okay.
I can keep.
Okay.
There is a picture of it. It's on video HD quality.
Oh, yeah.
But I didn't take a picture of
Yes.
it. And Mr. O'Donnell, on your phone, do you have a picture of $14,500 of cash?
Yes, in my lap.
And is there a way to tell the date that that picture was taken?
Yeah, the photos you take on an iPhone give you a digital tag on them. They tell you the time, location, and date photos.
Could you bring that picture? Can you make that available so that the court and the opposing counsel could see that? So
Yeah,
I
sure. Good.
It's ready to go. Okay. You want our permission to approach?
Yes.
Photograph.
Oh, absolutely.
Here's my COVID test for it. And here's the cash.
We can all look at.
I'll let the judge take a look first.
Monday, January 31st, 10:30 a.m., low battery. It shows some, looks like hip hop videos of stacks of $100 bill.
That's not how it is, Your Honor.
I think it's closing up on me right now.
Oh, low battery. Let's go like that close.
You asked me why. I
Oh,
didn't
I'm
think I
sorry.
could
Oh,
take pictures,
geez,
but
I hate these phones. I
Okay.
don't know how to work them.
Let's go back to it here. Can you go back to that picture? Try it. Mr. O'Donnell, this picture is large stacks of $100 bills of cash, correct?
Yes,
How much money is in there?
this one is 10,000 in that bundle.
How much is on the bundle on the left?
I believe that is 4,000
4,000 or 5,000?
or 5,000.
Somewhere around there, correct?
Yes,
And what's the date that this picture was taken?
January 31st, 2022 at 10:30 a.m. Let's see where it's taken.
Is that the money that you gave to Ms. Blair on January 31st?
Yes, it is.
I am, there's a couple options here. I don't have a physical copy of the exhibit, so we can either ask the judge to take judicial notice of it, or we can supply a copy afterward. But we would ask that be exhibited, or admitted in evidence, Your Honor.
All right, we'll call that exhibit 25.
And I would object to that, Your Honor. We had all the exhibits here and suddenly this one appears out of the blue. It doesn't have any indication of the actual amount, and it doesn't have any indication that it was given to Rosemary Blair.
All right, over the objection, he can email it to you, you can print it and make it part of the file.
Thank you, Your Honor. You were asked some questions about a loan application that you started in August of 2022, correct?
Yes.
And that loan application was for the remainder of the purchase price for the property?
Yes.
That was through First American Heritage, correct? So what was the date that Ms. Blair sent you the text message to close on the property?
August 4th.
And what was the date that you were kicked out of the property?
I think it was August, was it August 12th?
Around August 12th?
Yes, I think it's 12th or 15th, I forget what it was.
Does August 15th make?
Yes.
Well, let me refresh your, let me refresh your recollection. You go to exhibit 22.
It's the 15th.
Is that a condemnation notice that we went over previously?
Yes,
What's the date on that?
August 15th.
Okay, does that refresh your recollection?
Yes,
When were you kicked out of the property?
August 15th.
Okay, so August 4th and August 15th. It's not a lot of time to submit and be approved for a loan application in that period of time, is there?
No.
Objection, Your Honor. I don't think this witness has that knowledge as to whether or not a loan could have been finished and approved within that time frame.
I can lay a foundation, Your Honor.
We don't need to go dance on that ballroom floor. Obviously, you're not gonna have $338,000 loan in 9 days. So it just speaks for itself. The notice was on August 4th. And that was a Thursday. The zoning citation was August 12th.
That's what I thought, yeah.
So that's one, 6 business days.
Mr. O'Donnell, after you were kicked out of the house on August 15th, do you have knowledge that Ms. Bowers applied for a loan to purchase the property?
Yes.
And why did she apply for that?
I'm here to say, Your Honor, Ms. Bowers is here to testify.
No, I'm not offering it for the truth of the matter, sir, Your Honor.
All right, you can answer.
She had to buy another house to live in. She needed somewhere to live.
Did
She bought a house for 469,000.
do you have personal knowledge that she applied for a loan to purchase a different property?
Yes,
Because you're dating Ms. Bowers, correct?
yes,
Do you guys discuss your personal
Yes.
finances?
yes,
And that was to buy a home after she was kicked out of 11247 Lakeshore Drive, correct?
yes.
Do you know whether she was approved for that loan?
She was,
Did she buy a house with that loan?
she did,
What was the amount of that loan?
469,000.
So that loan exceeded 350,000, or excuse me, $338,000 that you guys owed under the land contract, or excuse me, under the lease with the option to purchase. I apologize.
Yes,
At a certain period of time, are you aware that the condemnation was lifted by the court?
no,
For
we
the
were never
property.
notified.
Well, but are you aware that at some point in time there
Yes,
was? Okay. After the condemnation was lifted, were you ever informed?
No,
Did Ms. Blair ever tell you you're welcome back on the property?
no,
What did she, instead of welcoming you back on the property, what did Ms. Blair do?
called the police. Listen.
At a certain point, did you actually file a lawsuit for an eviction of the property?
Yes.
For you? And that was a property that she was already in possession of, correct?
Yes,
No further questions, Your Honor.
I may, Your Honor.
Yes.
Mr. O'Donnell, you had to find out that the condemnation was lifted at some point in time.
in court
Okay, and so the court told you that.
in December.
Okay, in December, you knew that the condemnation was lifted,
Yes,
and you could have gone back in there and.
no. He wouldn't let us.
Well, he testified, he tried to go in November and October, and the doors were locked, and she called the state police. So he attempted to go back in after the condemnation was lifted, but was unable to do so.
But if it was lifted in December, Your
No, it
Honor,
was lifted before December. It was lifted, I believe, in September.
Your Honor, I believe that your order of September 6th says that nobody should be in the house.
Yeah, and at some point it's lifted. September 6th. Cannot be occupied. Consented to by the plaintiff. There's no mention in here anywhere of a tenant being in there. That was, and I was unaware there was a tenant in there. I feel, as I said, embarrassed. Ms. Blair is dealing with this as the property owner. There's no knowledge by the court that there's a lease option to buy. And I don't have the actual zoning file in front of me. I can't tell at what point it was lifted. I have a note of it somewhere. I think it was earlier than November.
I think it was done through a consent judgment, Your Honor, and Roxanne Sieber was the township's attorney.
Yes.
I think that's the September 6th one that says no.
That was the September 6th order that Miss Blair consented to. Somewhere I have a timeline myself. Well, I know where I can find it.
Well, Mr. O'Donnell, let's do the best we can under the circumstances. At some point in time, and I think it was in December, the court said lifted the order saying nobody could be in there. Do you agree that it was about that time?
But we weren't given notice.
Did you ever ask Miss Blair if she could go in? If you guys could go in?
She wouldn't respond to our contacts, any of our correspondence.
And did you go in of your own accord
Where's that?
into the house?
Yes.
Okay, so you know, you say that you may have not been told by the court or Miss Blair that you were able to go back into the house, when in fact you did go back into the house at periods of time.
For possessions,
Okay,
to get our stuff.
and at that point in time, had the utilities been shut off?
No,
No.
no.
Okay. And did you ask for the utilities to be put back in? Put back on?
When?
When you went back into the house?
No. Why would we? I don't know what you're talking about. They were never off. I don't really have, I never went in there when they were off. Utilities? They
Okay,
shut off the garbage. She shut off the garbage.
but the utilities were on, the heat was on?
Yes.
Okay.
The lights were on, everything was on, water was on.
Okay, furnishings in there?
Yes.
You could have stayed there if you wanted.
What are you talking about? She was gonna have us arrested. The cops are out there every night. I don't understand. I'm sorry. I'm not trying to be rude here. I don't understand you. I don't understand what you're trying to say.
Well, if we knew when the order was lifted, I guess that's the key here.
I can't tell from the file that I'm in.
Doug said in that first hearing, I swear he said November something.
I have a note of it somewhere, but I can't find it.
I mean, why the judge is looking at that, Mr. O'Donnell? Were you there at a hearing where Mr. Coleman testified?
Yes.
And when was that hearing?
The first hearing was in, I don't even remember, to be honest with you. I forget the date of the first hearing.
Approximate date, fall,
It
winter?
was just January, maybe she filed December, so maybe January, December 20th or something. Your first court date may have been December. She sent me something on December 20th when I got the lawsuit thing, and whenever the court was after December 20th, so it's probably January, I'm guessing. Ron, do you know?
Well,
There any question?
I'm just kind of waiting here.
The first hearing was set for January 6th. The defendant was served with a notice hearing on January 3rd. I can't answer the date easily on what date it was lifted. First set for January 6th, then it was going to be February 1st, then it got adjourned when Mr. Hatch got in the case. Then it got set for April 27th. I don't know the answer to that without
Okay,
suspending the record and going on a search. I thought it was in the zoning case, but there's very few notes in that file because it's a civil infraction.
okay, well, Your Honor, I'll do the best we can.
All right.
Um,
Consent order resolving the municipal infraction was September 6th.
Right,
Court accept the building official determination that the house was subject to being occupied due to structural damage. So there was no order that the court found that it was not to be occupied until September 6th. Then they were given opportunities to do other things. Now, this was all in the name of Rosemary Blair. There's no notice anywhere that any of this stuff was given to the tenants. And I can't tell, maybe I can see it in here. Because there was a subsequent inspection that it passed. It does refer to the tenants in his report, which I got at a later date. It's 84 pages long. I'm hoping to get to the bottom. Can't seem to speed it up. Darn it. Page 40.
I don't know if it'll work on there. If you hit Control N. I don't know if it'll bring you down to the bottom.
No. Move me back by 84. As I was leaving, I was advised there's a court hearing tomorrow at 8:16. This hearing is apparently a personal protection order where O'Donnell has placed a PPO against one of the neighboring property owners. Now, that report is dated 8/15, and there's no subsequent follow-up. I'm sorry, I don't have the answer in that file.
Mr. O'Donnell, were you aware that after the original condemnation, Mr. Coleman and others went out there and made changes and so forth, and the condemnation was taken off?
No,
You weren't there?
no,
You didn't ever
no,
talk to Mr. Coleman about it?
no,
You ever see the stickers go away?
no,
Stickers still there today?
I don't know, no, I don't see.
Oh,
where it is.
here it is. Douglas Kuhlman. On November 16th, I received photographs and a message from Matt and Van Dam at Cruising to Construction. They had made the repairs that would stabilize the grass wall from the state of collapse. Matt has advised once they stabilize the grass wall, they will send the township photographs and they have the township's permission to remove the condemnation. At this point, the dwelling is no longer deemed condemned on behalf of Fabius Township. I have contacted the property owner and advised her the dwelling is no longer considered condemned. She may now enter the dwelling and move forward with her plans. So the condemnation was lifted by Officer Coleman on November 16th of 2022.
Thank you, Your Honor.
Took me a long time to get there, but
by November 16th, Mr. O'Donnell, the pipes wouldn't have frozen by that time, would they?
No,
Objection to form calls for speculation. You can answer. Well,
He's a builder, he
personal
says.
knowledge.
it's not freezing on November.
Well, he's just gonna answer no, because they won't, so why object? Just let him answer it, and then we'll move on to the next question. No, the pipes wouldn't have froze by November 15th last year, would they?
No,
And the furnace wouldn't have just gone kaput by that time over that, was it 2 months maybe?
I don't think so. I don't know.
When did you go back into the house after November 16th?
Probably a couple of a month later, October or something. I forget. I was in November, October. I was in there a few times.
And was there furniture there?
There was some.
Yeah. And the lights and the utilities all seem to be working?
For the most part, yes.
And you could have moved in there if you wished.
No, because how could we move in there when they have the police coming after us?
Did the police come after you after November 16th?
Yes. On November 15th, they came after. She called them on me on November 15th.
And after November 16th, did they come?
Yes, October, they came out again.
No, that's
November.
before November. Did Mrs. Blair ever advise you that the condemnation had been lifted on the premises?
No, she did not.
Did Officer Coleman ever advise you as the
No, he did
tenant?
not.
So you didn't know the condemnation
Not
had
until
been
we were in
lifted,
court with you, Your Honor.
which was January 6th.
Yes.
And by that time, you knew it had been,
We heard about that day in the court.
okay. Did you move in after that?
We weren't allowed to.
I prohibited it.
After that time?
I said nobody was to go in there after, till we sorted it out.
Very good, Your Honor.
Anything further?
Nothing further.
Nothing further with this witness, Your Honor.
Am I done?
Yes,
Yes.
you can step down. Thank you.
Thank you.
Yes.
All right. Do you wish to call Ms. Bowers?
We do, Your Honor. As our second final witness, we will call Carla Bowers.
Good afternoon. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Thank you. Please have a seat, state your name, and spell your first and last name.
Carla Bowers, CarlaBowers.
Ms. Bowers, I know you have a little bit of a hearing problem, so if you can't hear me, feel free to speak up and let me know. Okay, thank you. Ms. Bowers, what is your current address?
221 South Berrien Street in Buffalo.
And is that the address where you permanently reside?
Yes.
And how long have you lived at that address?
I closed on that property on September 30th of 2022.
And do you own the house at 221 South Berrien Street?
City.
And where did you reside before you moved to 221 South Berrien Street?
Well, when I purchased that property, I was with my parents in Crete, Illinois, because before that we were living at the property in Quarry Lake, 11247 Lakeshore.
And after you were kicked out of the property at Quarry Lake 11247 Lakeshore Drive, were you forced to go live with your parents?
I didn't have anywhere else to go, yeah.
And how old are you here today?
41.
And I'm sorry, let me back up. When did you purchase the property at 221 South Berrien Street?
The closing date was September 30th, 2022.
Okay, so in between the time of August 2022 and the end of September, you were living with your parents in Illinois, correct?
Yeah. I'm scrambling to find something to move into, yeah. Because I mean, I didn't want to stay there with my kids.
And you have 3 biological children?
I do.
Okay. And you're familiar with Joe O'Donnell, correct?
Yeah.
Okay. And do you treat Mr. O'Donnell's children as your own?
I do.
And does Mr. O'Donnell treat your children as his own?
He does.
Where were you born?
I was born in Harvey, Illinois, grew up in Crete, Illinois.
Crete, Illinois?
Your Honor, I know Miss Bowers is soft-spoken. Maybe if she got closer to the
Microphone.
microphone, that might help, because I can
Perhaps,
barely
yes,
hear
thank
her.
Loud and proud. You grew up in Crete, Illinois.
I did.
And where did you attend high school?
Cremoni High School,
And what year did you graduate from high school?
1999.
And did you attend college?
I did.
And what college did you attend?
Moraine Valley Community College in Palos Heights, Illinois.
And did you obtain a degree?
Associates in nursing.
And are you a registered nurse?
I am.
What states are you licensed in?
I am a travel nurse, so I am licensed in Illinois, Michigan, Indiana, and Virginia.
And how long have you been licensed as a nurse?
2019.
And you're an RN?
I am.
And what areas of nursing do you specialize in?
I'm on the medical oncology floor right now. I do ortho, neuro, cardiac, post-surge. I float throughout the hospital.
Right.
Where are you
Medical,
presently employed? Where are you presently?
So I actually am employed with Aya Healthcare. They're based out of California. It's a travel nursing travel agency, but I am currently at Lakeland, which is now Corwell in St. Joe, Michigan.
All right.
you stole my next question again. All right, I want to direct you what's marked for purpose of identification as Exhibit 15 in the book in front of you. Can you turn it up, please? Have you seen this document before?
Yes,
Are you familiar with this document?
I am.
And what is this document?
Is there 2 pages here?
We'll just talk about the first page.
This is a text message between Rosemary and myself.
And were you a party to this text message?
Yes.
Can you hear her?
Yes.
Okay.
You speak up maybe a little bit more. And does this text message appear to be a true and accurate copy of the original?
Yes, it does.
And what is the name at the top of the text message thread?
Rosemary?
And is that how you store Miss Blair in your cellular device?
Yes, it is.
And whose text messages are in blue bubbles on the right?
Those are mine.
Okay, and whose text messages are in white bubbles on the left?
Rosemary.
Your Honor, we ask that Exhibit 15 be admitted into evidence.
Your Honor, first of all, Exhibit 15 seems to be more than one page.
That's true. We haven't gotten to the next part
We
yet.
haven't gotten anywhere there. As to the first page, there's nothing about money or anything like that. Seems like just a conversation. And so I have no question of, I don't believe there's any.
Well, at that point, you're going to go to Rosemary's and drop something off. Is that correct?
Well, it says that I'm at the bank in Crown Point.
Mhm.
Are you home? Is it okay to stop by and drop this off in a few minutes?
All right.
So Your Honor, I'm gonna go with this text message where I went with all the other text messages, which
Yeah.
is establish a foundation. and
Well,
then
go
ask the
ahead,
witness.
and then we'll hear your motion. But there's also other stuff that
And
appears to.
the second page, we're not offering into evidence, Your Honor. It's just the first page that we're offering into
All right.
evidence.
So this is a text message that you sent to Rosemary and she responded.
Correct.
All right, for that purpose, it's admitted.
And what is the date at the top of this text message, Ms. Bowers?
May 4th, 2022.
And I want to direct you to the text message where you state, "Hi, Rosemary, it's Carla. I'm at the bank in Crown Point. Are you home? And is it okay to stop by and drop this off in a few minutes?" Do you see that?
I do.
What were you referring to in that text message?
The $2,000 that I paid her, and if I had hindsight that this was going to be an issue, I would have said, I'm going to drop off $2,000, but I didn't know that this was gonna take place, so I didn't do that.
And did you actually meet up with Miss Blair on May 4th of 2022?
Yes, I did,
Where did you meet Miss Blair?
at her home in Crown Point.
And did you pay Miss Blair any money on May 4th of 2022.
I paid her $2,000 towards the purchase of 11247 Lakeshore Drive
And how did you make that payment?
in cash, in person.
And you handed the money to Ms. Blair?
I did.
And again, what was that payment relating to?
The purchase of 11247 Lakeshore Drive.
Green light, can you put a sticker up next to exhibit 15 on there for me? Ms. Bowers, you were sitting in the court and you heard Mr. O'Donnell testify here today, correct?
Yes, I did.
And that testimony generally had to do with Rosemary Blair and the events that surrounded 11247 Lakeshore Drive, correct?
Correct.
Is there anything that Mr. O'Donnell said that you have personal knowledge of that you disagree with?
No.
Now I want to get into, there's been some questions here today about why you and Joe gave cash payments to Rosemary. Did you have discussions with Rosemary about the cash payments you were going to make for the purchase of the property?
Yeah, we did.
And what did Ms. Blair tell you about those cash payments?
She said that her and her children were estranged. She did not have a relationship with them, and I guess they had a falling out over some property in Texas. She was getting money from that land out there, and they were essentially, I guess, taking money. They had access to her bank account, they had access to all her records. So everything she wanted to do was in cash.
So was it Ms. Blair's request that you pay her cash?
Yes, it was.
And you guys comply with that request?
We didn't have a reason not to at the time. We had a relationship with her. Yeah. So we had no reason to believe that this was ever going to be an issue.
Let's talk about your relationship really quickly with Ms. Blair. Do you see a picture in front of the podium right here?
I do.
Can you describe to me what that picture is?
I believe that was one of the first couple days or something that we were at the home at Corey Lake. That's me, my son Joey, Joe's son Joey, and my daughter McKenna and Rosemary. And we're standing, that's like right kind of in front of the front door, taking a picture. She actually stayed there, I think, that weekend with us and just hung out and enjoyed the house and the lake, and there was a relationship there.
Yeah.
So
And would that be around June of 2021?
yes, it was.
And whose arms does Ms. Blair have? Her arms, or whose arms is she wrapping her arms around that picture?
That's Joey O and McKenna.
So that would be Joey O'Donnell?
Yes.
And that would be McKenna, your biological child?
Correct.
So at that point in time, it's suffice it to say that you had a good relationship with Ms. Blair, correct?
Yeah.
Fast forward 2 years, did you ever expect that you'd be here today?
Not at all.
How does it make you feel that you're here today?
Frustrated, disappointed, angry.
Hopefully.
Your Honor, that's an appropriate commentary.
Yes.
I'll retract my statement. I apologize. All right, we're rounding home base with you now too, Ms. Flowers. I want to talk about the mortgage that Mr. O'Donnell testified that you got for your property in New Buffalo. Again, what's the address of your property in New Buffalo?
221 South Berrien Street in New Buffalo.
Okay, and why were you forced to buy that home?
At that time, I was scrambling for, the kids were starting school. I mean, school begins after Labor Day. I mean, I ended up closing after that, but they needed a home. I needed a home. And I was working in St. Joe, Michigan. We were supposed to be at Corey, and I ended up in New Buffalo. That's where Joe was. The kids, I mean, we had a little bit of a background there, so that's where we ended up. But
Okay. So did you have to purchase that property for replacement housing after you kicked out of Corey Lake?
Yeah.
Is that because your children were attending the New Buffalo schools?
I enrolled them last minute there, yeah.
And You obtained a mortgage. Is it correct that you obtained a mortgage to purchase that property?
I did.
And what date did you obtain that mortgage?
The closing date was September 30th, 2022.
2022? Sorry, I didn't hear you. And what was the amount of the mortgage?
469,000.
So within the 90-day time frame after August 4th of 2022, you were able to obtain a mortgage for $469,000.
I was,
correct? And does that $469,000 exceed the amount that you and Mr. O'Donnell were going to pay on the remaining purchase price of the lease with option of purchase?
It does not exceed the amount. What do you mean?
Objection, Your Honor, I
Like
think
in
there's
addition to
little
that?
coaching here.
Let me restate the question. Does the $469,000 exceed?
Oh, the three, yes, yeah.
Yeah, so you had a remaining purchase price that you were going to owe for closing on the Quarry Lake home, is that correct?
Correct,
That was $338,000.
correct.
And does the $469,000 exceed the
Yes, it
338?
does.
So were you able to obtain financing to pay off
Yes, I
the Quarry
was.
Lake? Pass the witness.
Ms. Bowers, when did you vacate the Quarry Lake house?
Well, when I was kicked out on August 12th, I think was when they actually came in and to the bedroom where I was sleeping and got me out of bed and said we had to leave.
When did you start the process to obtain a loan?
For the house that I'm in now.
Correct.
Sometime in August, I mean, right before the kids ended up going back to school, so probably beginning of September and August sometime.
You're not sure?
I mean, I'll probably go on my phone and look and see when the application was turned in.
Okay.
Yeah.
Where did you obtain your mortgage? From whom did you obtain your mortgage?
I ended up going through United,
Wholesale mortgage?
I'm sorry,
Oh, United Wholesale Mortgage? Never mind, that was just a guess.
no, it was a different one. I can't remember actually. United Federal, I think.
Okay. Is that a bank credit union or a credit
Yes.
union? Okay. Where are they located?
There's branches all over.
Okay. What branch did you do your loan approval from?
I think it was Stevensville.
Okay. And when you left the house, was Mr. O'Donnell still there or was he already gone?
Like the exact moment I left the house.
Well, kind of
Did we leave
like,
together? I mean, I don't remember. I had to go to work that night. So I
Okay.
think I just ended up going in early.
well, when you came back, did you pack up and then go? Were there Mr. O'Donnell
Well, I had to
had
leave.
already gone or?
Well, like I said, I had to go to work that night. So I went to work. I didn't have time to pack up all my stuff. So I did end up coming back. They kicked us out again. I didn't have time to get my stuff. And then I ended up going back with a truck and getting everything at a later date. I believe in September,
Mid-September?
October. I
Late
think
September?
October, because that was after I purchased the home. So.
So you moved all your stuff out of the Quarry Lake home into the Berrien Street?
Yes.
Okay, good. Berrien Street
Well, I
home.
think I got a storage unit for some of it, but yeah.
Okay. And when you vacated the Quarry Lake home, did you ask that the utilities and electric and all that sort of thing be
So-
taken out of your name?
Yes.
Okay.
Can I expand on that?
Well, when did you ask for them to be taken out?
So the electric, I believe, was through October and the gas was through November. It was still on in my name through those dates.
Now, do you live with Mr. O'Donnell now?
No,
And he lives at on Barton Street?
he's at 28 North Barton Street. I'm at 221 South Berrien. They're like 2 minutes apart from each other.
Then they're not the same house or whatever.
No, they're separate addresses.
And when you say you went to live with your parents for a bit, did Mr. O'Donnell go with you?
No, he was at other residences. He was like you said, like couch surfing. I think he went up to Traverse City for a little bit and he was like with other friends.
Okay.
But I had kids. I mean, I couldn't couch surf with kids. You know?
And the kids are going to the New Buffalo schools
Yes, they
right
are.
now. Yeah, good. You heard Mr. O'Donnell say that whenever he gave Miss Blair some money, except with certain exceptions, he always took a picture of the cash or her with the money or something like that. Did you think to do that?
No, I didn't actually.
Okay. Okay, fair enough. I have nothing further, Your Honor.
Any further?
Nothing further, Your Honor.
Ms. Bowers, you can step down.
Your Honor, I would request just a brief closing statement. I don't know if now is a good time for maybe a mid-afternoon break, and then I don't expect closing to go more than 10 or 15 minutes.
That's fine. I don't know if Mr. Soltis wants to present anything, but he's prohibited from.
Well, Your Honor, am I permitted to at least comment on the evidence that
Oh,
has
certainly.
been presented?
Certainly.
Yeah, and I'm ready to go whenever.
All right,
the court-
let's take a short break, how about 2:45. Maybe we'll get where we need to be.
I'm sorry.
4:45. 4:45.
4:45,
I'm
okay.
gonna go back in time.
Thank you.
Exhibit 15 is admitted.
So this place is, they need to turn this air.
Well, we have two options, too hot or too cold.
Right, it's always that way.
Yes, and when you're up here in a long black dress and no air, it gets awfully hot. So I have about zero control over the temperature in here, and I apologize. All right, let's go back on the record. I didn't think to ask. Are you either Karen Stiver or Patrick Blair? You're just, yeah, either. So those parties aren't here.
Your Honor, those are the parents of Carl Bowers.
Oh, okay. Well, you're certainly welcome to be here as a spectator. All right, we've finished the evidence portion of this hearing regarding specific performance. I have 25 exhibits and a day's worth of sworn testimony. Mr. Hatch, what would you like me to know?
Thank you, Your Honor. In June of 2021, Joe O'Donnell and Carla Bowers moved into the lakefront property at 11247 Lakeshore Drive with their 5 children to live the American dream as a single nuclear family. Over the past 2 years, Rosemary Blair has done everything in her power to turn that dream into a nightmare and ruin their lives. Today, on June 28th of 2023, almost 2 years to the day after they first moved into the property, we ask that the court give Joe, Carla, and their family their lives back by holding Ms. Blair accountable for her actions. First and foremost, I want to sincerely thank the court for its attention and listening to the testimony here today, and on a broader scale for its patience in dealing with this case over the past 6 months. Closing argument is not the time to rehash everything that has occurred before trial, but I think the court would agree with me that this case has turned into something that it should have never been. Ms. Blair could have entirely resolved this dispute by owning up to the mistake that she made when she unlawfully kicked Joe, Carla, and their children out of the property in August of 2022. Had she simply let my clients back into the property and moved forward with the sale of the house, none of us would be here today. Joe and Carla's life together would have never been uprooted. Their relationship would have never been plagued with stress and mistrust. And most importantly, they would have never had to explain to their children why they lost their home. But that resolution would have required Ms. Blair to do something that she has shown time and time again that she is incapable of doing, playing by the rules and admitting that she was wrong. As the undisputed evidence is shown here today, Joe and Carla entered into a valid and enforceable contract with Ms. Blair to buy the property at 11247 Lakeshore Drive. Between June of 2021 and July of 2022, Joe and Carla paid Ms. Blair a total of $112,000 towards the $450,000 purchase price of the property. Then in August of 2022, when Ms. Blair indicated she wanted to close on the sale of the property and collect the remainder of the purchase price, Joe and Carla worked to secure financing and were ready, willing, and able to consummate the sale of the property within 90 days. But everything changed in August of 2022. At that time, Ms. Blair turned into, quite frankly, a bad decision-making factory. She got seller's remorse when she was confronted with the reality that she was going to have to part ways with the property that she owned forever. To get out of the land contract, Ms. Blair executed with Joe and Carla. She had her own property condemned and then turned around and attempted to use that condemnation as a means to terminate the land contract, the lease with option to purchase. She then hired a lawyer to send threatening letters to Joe and Carla demanding that they vacate the property. And at the same time, she took matters into her own hands by unlawfully locking them out of the property. And after she locked Joe and Carla out of their home, she stole countless items of their personal property, including boats, beach chairs, rafts, grills, coolers, speakers, life jackets, and even a snowmobile and snowmobile. Miss Blair is a deeply troubled person, violently unafraid that there are consequences for her actions. And in her relationship with Joe and Carla, she was downright cruel. She has lied to the court countless times, claiming that she was only paid $30,000 towards the purchase of her home. She apparently forgot about the other $82,000 of cash that she was paid by Joe and Carla when she was, in her own words, desperate for cash. She has also come up with ridiculous positions that bear no semblance to the truth, such as her claim that she lacked the mental capacity to execute the lease with the option to purchase, which is the same lease with the option to purchase that she relied on to kick Joe and Carla out of the property. What Miss Blair did in this case was an act of profound cruelty, not just to Joe and Carla, but also to their children. Thankfully, the court can provide a remedy for that wrong that have been inflicted upon Joe and Carla through its equitable powers of the grant of specific performance. There are 4 elements to a claim of specific performance, all of which have been proven here today by a preponderance of the evidence. In fact, more than a preponderance of evidence, I would attest by clear and convincing evidence. The first element is a valid and enforceable contract between the parties. Here, Joe O'Donnell, Carla Bowers, and Rosemary Blair entered into a valid and enforceable written contract for the sale of 11247 Lakeshore Drive, and that contract was admitted into evidence as Exhibit 18 and has a inclusionary term integration clause that said is the final contract and supersedes all prior negotiations and agreements between the parties. That is the binding agreement between the parties here today. The second requirement is compliance with the contract by the party seeking specific performance. You heard undisputed testimony here today that Joe and Carla comply with all of their obligations under the lease with the option to purchase and were never defaulted by Ms. Blair. The third requirement is a breach of the contract. Now, it's already been established through the default that Ms. Blair breached the lease with option to purchase by, among other things, removing Joe and Carla from the property without lawful cause and locking them out of the property in violation of the Michigan anti-lockout statute. And finally, the fourth requirement is that the subject matter of the contract is unique. The Michigan Supreme Court has held, and I quote, "In cases concerning breaches of real estate contracts, land is presumed to have a unique and peculiar value, and contracts involving land are generally subject to specific performance." That is Henry Smith Trust 480 Mich 19, a 2008 case. And you also heard the undisputed testimony from Joe O'Donnell here today that the lake house was uniquely situated to meet the needs of his family and Carla's family and their unified family. And he has been unable to find another capable property at a comparable price. So all of the elements of specific performance have been met, not by a preponderance of the evidence, but by clear and convincing evidence here today. So I'm going to go back to what I started out with in opening statements. And I told you at the close of our proofs, we were going to request specific items of specific performance from this court. We asked that the court enter a judgment in favor of Joe O'Donnell and Carla Bowers and against counter defendant Rosemary Blair, ordering that Ms. Blair to perform her obligations under the land contract, the lease with option to purchase. Second, we ask that the court enter an order requiring Rosemary Blair to execute all of the documents and instruments necessary to sell and transfer the real property located at 11247 Lakeshore Drive in Three Rivers, Michigan, in fee simple absolutes to Joe O'Donnell and Carla Bowers, free and clear of any liens and encumbrances after the parties close on the sale of the property. And we also asked that the court enter an order requiring the purchase price of $338,000 that's remaining under the lease with option to purchase to be set off through set off and recoupments by the money damages that Joe O'Donnell and Carla Bowers are awarded potentially in the circuit courts with their claims against Rosemary Blair. Also, we would ask that the court order under specific performance that Ms. Blair return some of the larger ticket items of personal property, such as the HydroStream boat and the pontoon tracker pontoon boats that you heard Mr. O'Donnell testify about here today, so they can enjoy the lake house. And Your Honor, I know we spoke about the equitable remedy of specific performance and whether the court can order a set off for the remaining of the purchase price. And the case law states that you can. Set off is an equitable remedy, and this is out of a Michigan Court of Appeals published case, Walker versus Farmers Insurance Exchange, 226 Mishap 75, a 1997 case. Set off is an equitable remedy, so an equitable remedy that the court can grant in addition to specific performance that may occur when two entities that owe money to each other apply their mutual debts against each other. So Carla Bowers and Joe O'Donnell are responsible to pay the remaining purchase price of $338,000 under the lease with option to purchase. Ms. Blair will potentially be responsible as a debtor to pay Joe O'Donnell and Carla Bowers damages under their claims that have been removed to the circuit court. So we would ask that as part of the request for specific performance that the court order a set off for the remaining price. And specific performance, the case law allows and encourages the court to grant such a remedy, Your Honor, because the big picture for specific performance is to put the parties, the non-breaching party, in the position that they would have been had the breaching party performed its obligations under the contract. So simply requiring Joe and Carla to pay the remainder of the $338,000 from today is not going to put them in the same position as they would have been had Ms. Blair consummated the transaction. Ms. Bowers has bought another house that she has paid a price that she will probably take a loss on today. And they are not in the financial position that they were before to necessarily, I'm not saying they couldn't do it, but it would be difficult to leverage their assets to get another $338,000 loan when they've had to spend that money to secure replacement property. And Ms. Bowers has had to purchase another house with it as well too. So it's not just as easy as say, hey, come up with another $338,000 because they're in a different position than they would have been if Ms. Blair would have performed the contract. The other option, Your Honor, is to possibly escrow the payments with the court for $338,000 until the circuit court decides the damages that will be offset by the $338,000. Not preferred, but if the court wants to go down that route, then that would make sure that they're not going to spend the next 20 years of their life chasing down to try to collect against Ms. Blair for the amount that they have to set off their set off recoupments. So with that, Your Honor, I appreciate your attention here today and nothing further.
All right, let me address that. One option is to order specific performance of the lease option to purchase. And the remaining price was $365,000. And plaintiff has established proof that $112,000 was paid, not 500. 365,000 minus 112,000 equals $253,000.
Your Honor, just to be honest, I think that the purchase price was $450,000.
Yeah, it's 450. Oh, yeah, you're right. I'm double dipping.
Yeah, minus the
450
112.
minus the 112,
So I think that would be a 338.
which is the figure we were using.
Yeah, please double check my math because I missed the $500 payment.
338,000 minus 2 additional escrow payments of $2,000. So there's $4,000 in escrow, which would be $334,000. One option is for the defendants to tender a certified check for $334,000 and you tender the deed to the house. That seems pretty straightforward, but as Mr. Hatch indicates, then there's going to be a hearing regarding damages. And then they're in a position where they need to try to collect what I expect to be substantial damages, well in excess of $25,000, possibly in excess of $100,000. So they're asking for a set-off. So rather than chase you for the money, reduce the amount that they owe by their damages. Mr. Soltis made a good point early in the case that we aren't going to know what the figure is until we know what the damages are. My option, they pay $334,000. They get the house, gives them free, clear, simple title right now, but then they may never recover their damages. The defendant may or may not have the money. She could possibly declare bankruptcy and wipe the debt out. So the wiser course is to use damages as an offset of the purchase price of the house. But as Mr. Soltis says, that's going to take quite some time. So they're going to be in a limbo position in the meantime. Although they do have a color of a lease. There's also the issues of the property taxes. I don't know when the taxes were last paid. The defendants haven't paid them, and I suspect Mrs. Blair hasn't paid them. And taxes on a $500,000 lakefront home are not insignificant, particularly if it's not homesteaded. So there's going to need to be some provision on who pays the taxes. And the lease option to purchase says the purchaser pays the taxes. Mr. Soltis, you've been doing a remarkable job considering how short of a time you've been in this complicated case. What are your thoughts on the matter?
Well, Your Honor, I generally agree with you. How about that? There's 3 counts that haven't been brought up to circuit. One is the summary possession. I think the court has already addressed that. And if not, then I will stipulate that Mr. O'Donnell and Miss Bauer can stay in the house as long as, until there is either a court order saying otherwise, or the don't exercise the option. So I don't think that really needs to be litigated.
All right.
The other aspect is quiet title. Quiet title, obviously, Your Honor, I don't think can be addressed until we know if they are going to exercise their option. And right now, that's still up in the air. So I think it would be premature. Now, with regard to specific performance, that's the key, I think, today. And I think this court can order that Ms. Blair follow the agreement. So if the O'Donnell and Bowers tender the 300 and, well, you say 334,000. I don't think they've proved all of that, but you're the judge. That she should, turn over the deed and things like that. Now, counsel has asked for all the liens, and that's contrary to the agreement. The agreement in the title section says landlord agrees to, and this is page 4, accept title to premises subject only to a lien for taxes and assessments. Well,
What section are you in?
I'm on title on page
Title, all right.
4.
Yeah, we've never inquired. We've been under the assumption that Miss Blair owns this property free and clear. I don't know whether that's true or not. I don't know if she has a note on it that she has to pay. But they are agreeing not to purchase it subject to any other note or lien, so except for taxes.
And Your Honor, I can tell you this. Miss Blair keeps telling me, and I believe her, and I think I may end up filing a motion for reconsideration, that she's been paying the taxes, that not Mr. O'Donnell has been paying the property taxes. So
Well-
I think we can get that, we can flesh that out,
All right.
but it won't happen today. And there's also the problem with the option consideration. There's $5,000. That money I don't think should be given to Mr. O'Donnell and Miss Blair at this point in time, because once again, we won't know if they are going to exercise the option. Will they come up with the money? Maybe yes, maybe no. Like you said, they could file bankruptcy. All kinds of things could happen. And so I think that money should be held in escrow perhaps by the court until we know for sure. If they do exercise the option, they get the $5,000. If they don't, then that should go to Miss Blair. So those are the things that they've been talking about with regard to the lease. Now, we really haven't had any evidence of the financial condition of Miss O'Donnell or Mr. O'Donnell and Miss Bowers. So for them to say, well, we can't do it and we're not unable to, well, Your Honor, maybe yes, maybe no. We don't have any evidence of where they stand, their profits, loss, and so forth. I do take umbrage with the idea that counsel says, well, they're going to, Miss Bowers is going to lose money on her house. Not too many people are losing money on their houses these days, I assure you. I mean, they keep going up and up and up. So if she does sell the house and makes a profit, well, good for her, but that, shouldn't be held against Miss Blair. So I guess, Your Honor, I'd say order specific performance, I think, as you've already adjudged. Order the parties, you can order, you don't have to order Mr. O'Donnell and Miss Blair, Miss Bowers rather, but you can order Miss Blair to follow the language and terms of the agreement. And then let's see where it goes. If she does, if the option is exercised, great.
The problem is, this is gonna take a long time. Miss Blair, this has been a long legal process for you. You've been through 4 lawyers. It's very frustrating. We're not done. Mr. O'Donnell and Miss Bowers, this completely upended your life. Everything was going fine. It was COVID summer 21, but people were outdoors during the summertime. August 4th, you're living in your house, your toes are in the water. 9 days later, somebody comes and tells you have to move out and everything's turned upside down. I don't know what happened between that date and the date that the zoning enforcement officers came. I have speculated about it, but I don't know what happened. Something changed. You had a good relationship with the seller. You'd given her inordinate amounts of cash, which is very unusual. You've given explanations for why it was done. Your banker must have thought you were crazy coming in there every few days asking for stacks of $100 bills. Over 100, over 10,000, they're supposed to report it to the IRS. And at any rate, I do find that they have proven beyond clear and convincing evidence that they gave her $112,000, even for the things that were not photographed. But the 14,000 was photographed. So I believe she got that amount of money. I never understood in the pleadings why there was a contention that she didn't, but that's going to be offset. You raise a very good point regarding the $5,000 lease option purchase default. I remember what clause that was in.
That's page 4, about 2/3 of the way down.
Yeah, option consideration. All right. I order specific performance that Rosemary Blair comply with the terms of the lease with option to purchase dated November 15th of 2021.
And Your Honor, I hate to say this in the middle of your
Yes.
hearing, but we'll probably need a date by which that order begins, because obviously we want to be able to say, okay, this is the 90 days.
Well,
So
the problem is we aren't going to be able to do it within 90 days because there's the whole issue regarding set off.
Okay.
Like I said, in the ideal world, they would tender a check for that amount of money within the next 90 days, and they would take fee simple title to the house. That's one way to do it. Then they have to go through the damage hearing and get a judgment. So it puts them in a position where they have to borrow money to cover that cost and then spend additional money to collect that money from Ms. Blair. Mr. Hatch and the defendants are saying, look, let us have our hearing regarding money damages and we'll offset that against the price of the house. That's why it's going to take longer than 90 days. It'll take longer than 90 days to get the transcript prepared. So I have a wording in mind,
Okay.
but she has to comply with the lease option to purchase. Mr. Hatch, you're gonna do this order, so we'll make sure we're all on the same page. Defendants shall be credited with $107,000 of payment. $5,000 of the option consideration shall be held in escrow. To be applied to the sale if completed. Or return to the plaintiff if not. Defendants shall be entitled to application of all other escrow funds. Which is currently $4,000, but shall, another payment's due in just a couple of days. They've been pretty good about making their payments in a timely manner. I'm gonna continue the escrow order in this court. $2,000 per month. I'm going to order that the defendant purchaser pay the 2023 property taxes. The defendants shall be entitled to a set off against the purchase price of damages to be determined by the circuit court. Once that figure is established, defendants shall have 90 days to execute the sale. To extent the property still exists, plaintiff shall return the Four Winds ski boat,
Sorry, on our hydrojet ski boat,
hydrojet.
hydro stream.
I got Four Winds Casino.
That's exactly.
That is where it came from.
Stream ski boat.
And the Sun Cruiser,
No, well, that's right.
Sun Tracker.
Sun Tracker, yeah, that's the sailboat.
No, that's the pontoon boat.
Oh, okay.
The Hobie Cat sailboat. Paddleboard, paddleboat. Canoe. As well as, I think this property has been dissipated or it's gone, but the snowmobile. What brand is it?
That was I think it's Kawasaki.
What's a small wheel?
Snowmobile.
Oh, snowmobile, I'm sorry.
Snowmobile and a snow blower. And other personal property as requested. If it still exists, I think that somebody told me they saw the snowmobile.
It was a Polaris, Your Honor.
A Polaris. Or that shall be added to the damage claim. That's within 30 days. Defendant shall otherwise comply with all the terms of the lease option to purchase. I don't need to know this, but I want to know it. Do you have an estimate on what the plumbing repairs are after the property froze?
Probably somewhere around 3,000.
All right, so it's not exorbitant, but you're gonna be responsible for restoring the habitability at this point. This is gonna be your house.
Yeah, but that doesn't, the furnace is shot. I don't know if that.
Sorry, I didn't hear that.
He just said the furnace is also ruined, but again, I think that'll be part of the damage.
So either you can just leave it vacant, pay $2,000 a month for a property you may not be able to access, or effect those repairs yourself and make it part of your damage claim to be able to use the property. I'm familiar with this property. My cousin used to live across the street from it. There are some Airbnbs just down the street. A family that my son knows from Park Ridge, Illinois, rented a house a few houses away from this and had a wonderful family time. People like me that live here in St. Joe County with all of our lakes take for granted what other people don't often get to enjoy, which is lakefront life. It's about as good as it gets in the summertime. All right. Have I omitted anything that should also be in the order?
I don't believe so, Your Honor. I just, so there's gonna be three orders that I will prepare. The direct contempt for $6,500 within 30 days of today, which I believe we addressed at the
Yes.
beginning of today.
That's not offset against the purchase price. That's just.
That's just paid straight out, right?
Right.
Yeah. And I'll have it be paid to my firm's IOLTA accounts, just so we don't have any issues about how it gets delivered, if that's acceptable to the court.
Yes.
Order number 2, removing all claims to the circuit court that we put on the record today. And then the court's ruling opinion and order today. I think I've got all of that down, and if not, I will be sure to go back and listen to the recording today to confirm. And would you like me to submit that under the 7-day order?
That would be fine. We'll have Mr. Soltis an opportunity to look at it.
Okay. And nothing else from us, Your Honor. Thank you very much.
All right, thank you. Anything further, Mr. Soltis?
No, I think you've covered it all, Your Honor.
All right, we did accomplish this in a day with a couple of criminal interruptions here and there. Thank you all, and we'll be in recess. Have another full day tomorrow. With another 40 or so cases to address.